Well, hello there. My name is Alex, and I'm about to become a political prisoner in the United States of America, and specifically in California. I want to tell you about, at least a little bit about how that came to be and what's going on. And I'm outdoors right now, so I'll apologize if there's any extra noise. There's a road right over here to my left, so some cars might go by and maybe some people might come by, but I want to take every opportunity that I can to be outdoors while I still can, as there's a very good chance that in a month or so that I will be going away for a considerable period of time. So why would that be? Well, I've been charged with contempt of court, and while on the advice of my public defender, I can't make specific comments about the exact charges. There will come a time for that. I can say that I'm absolutely 100% innocent of all of these charges, but well, what is contempt of court? Contempt of court really is just a judge's opinion that you offended the court in some way. So if you think about it, it is a tool that can be used when somebody like me needs to be silenced. And it has been used many times on other people in the past in this country. And as far as I can tell, it's about to be used on me. So why would I need to be silenced? And who is it exactly that's trying to silence me? Well, I know too much. I know too much about a few things. I know too much about some forms of fraud and corruption that are taking place in the music business, where I was for many, many years writing and producing music for film and television. And I became aware of some types of corruption. Two things, basically. One is called ghostwriting, and the other is called direct licensing. And I'll maybe say a little bit about what those two things mean. And then beyond that, in trying to achieve justice for myself and bringing lawsuits in courts of law, in both federal court and state court here in California, in Los Angeles Superior Court, I became aware, too aware, acutely aware of forms of corruption in the court system. And let me just say that while my profession for many, many years was writing and producing music, I have in recent years gone to law school, and I hold a Juris Doctorate. And I say that only to explain that I know the difference between a judge's ruling that I don't like versus a judge doing something just illegal and just outside the bounds of what the law says that they're supposed to be able to do. And so there's been plenty of both of those things, but what I want to talk about today is what I'm trying to do in addition to fighting these contempt charges, and that is bring a motion for a new trial, and just on one little aspect of the litigation that I've been trying to pursue. And I want to explain what happened at this recent trial, and how what the judge did was just completely out of bounds. So on music business corruption, so there's a very widespread practice called ghostwriting. And ghostwriting in music is essentially what happens when one composer or songwriter has the gig, has connections to a lot of gigs, a lot of jobs, and there's way more work than that one songwriter, composer can actually do. And so what a lot of like TV writers and production music writers who have these connections will do is essentially form a team of other writers to actually do the work in the recording studio of writing and producing the music, which ends up being very time consuming to do. And then taking credit, either all of the credit or part of the songwriting credit for themselves. And by setting things up that way, a well-positioned person can get their name as a writer on hundreds or thousands of pieces of music that they didn't actually write. And that entitles them, of course, to collect the royalty money that accrues from that. And the record companies and the big entertainment corporations, they know perfectly well that this is going on. And really a lot of these people who engage in this ghostwriting are really acting more like an agent, right? But there's a reason why agents are only allowed by law to take like 15%. But instead, you have ghostwriters that they either take 100% or 90% or 50%. Or what have you. So, and in my case, my ghostwriting arrangement happened to be with my wife, who was also my business partner for all those years. And she had this great connection at this record company that was in the business of producing all this music for film and television that gets produced ahead of time and then licensed to various TV shows. And then when the music plays on a show, then there's a performance royalty that then comes back to the writer. In the midst of all this, about maybe 15 years ago, this record company that had already been working for 10 years got acquired by a giant corporation that you have absolutely heard of. I don't actually need to mention what the name of that giant corporation is, but just be aware that it's a giant, huge, international, multinational conglomerate, a media conglomerate with just tremendous money and power. The second kind of fraud and corruption that I became aware of was, let me back up a second and just say that in my personal situation, I agreed to be a ghostwriter with my wife / business partner because, we were married, we were parents, and we were supposed to split everything 50-50 anyway. So we just had an agreement that we would split all of the writer credits and therefore the writer money 50-50. And we just put ourselves down 50-50 as writers on everything. That is, she did that. She was in charge of all of the business and all of the registrations and all of that junk. So as it turned out, she started taking 75% of a lot of songs, and then 90% of a lot of songs, and then 100% of a lot of songs. And I later found out that the record company people, who she was very, very tight with and was in bed with, at least figuratively, if not more, they knew all about this. And my ex-wife, my now ex-wife, ended up putting our business solely in her own name and secret bank accounts and this whole just horrific thing that started coming out as we went into divorce. So the second kind of fraud that I became aware of in the music business is called direct licensing. Now, when a songwriter such as myself does these production music libraries, the writer gives the copyright ownership to the record company. And the only rights that the writer holds on to is the right to collect performance royalties. All the licensing fees, the record company just keeps that. So the writer only gets a performance royalty after the song plays on a TV show, which we're very fortunate. I've had many thousands, actually, of songs that have been performed on TV shows and other media, but mostly a lot of TV shows. When that giant multinational corporation acquired the record company, they did so because they also have a lot of TV shows that they're producing, and they had been licensing a lot of music from this company, and they just decided that it was cheaper and better for them just to buy the company, which is what they did. And when they did that, unbeknownst to me, they started doing this thing called a direct license, which basically means they're going to take and use the music and set it up in such a way that performance royalties do not have to be paid to the writer. Now that's just wrong and unfair. So I became aware of these things, and I started trying to pursue justice against my then ex-wife, who and the record company, and all of this, because there's just a lot of money that I got screwed out of. And a lot of people have asked me when I tell this story, man, what did you do to your wife, man? Why did your wife get so pissed? Why did she get so pissed off at you? Why did she want to ruin you? And it is true, and I have to admit, there was some infidelity in my marriage, and maybe at a future time I'll talk more about that. I don't know, but there's a lot to be said. So now I still have. There's been a whole long drama of the lawsuits, plural, that I have brought. I actually succeeded in a copyright infringement case back in 2016 against my ex-wife. I won on that. I was declared the sole author of these 11 particular songs, and I was awarded like $23,000 in damages. And she and her attorneys appealed this to the Ninth Circuit. I prevailed on appeal. And when that happened, while the record company was not directly involved in that lawsuit, they got involved. The vice president filed a declaration into the case when that case was going on, falsely stating that the record company did not pay royalties. Because what I found out in the course of doing this was, in fact, the record company was paying royalties. You see, and that's very unusual, because as I explained, normally it is these performing rights organizations like ASCAP and BMI, they pay the writer royalties, the performance royalties. But because they had instituted this policy of doing these direct licenses, and they were bypassing the performance royalties, they secretly set up this other royalty stream in order to basically keep my ex-wife from going crazy about not getting her performance royalties. So they set this secret royalty up that she was getting on my music, that I wasn't getting and didn't know anything about. And then I found it out. And now this vice president of the record company comes to court and just falsely says that they don't even pay royalties, which ordinarily would be true. So, and I knew he was lying under oath, and they knew that I knew that he was lying under oath. And so it became very, very important for this multi-billion-dollar corporation to take a very keen interest in the litigation between me and my ex-wife. And at that time, my ex-wife got rid of her one attorney, her family law attorney, who was handling all of her litigation. And she brought in this army of very high-priced lawyers from 3 different law firms. So she has this one guy who's a criminal defense and a family law lawyer. And that's one whole firm. And then this intellectual property law firm, and then a civil litigation law firm. There are 3 different firms with about 7 or 8 high-paid, high-priced, powerful lawyers who then all started working in concert and in combination. And to this date now, my ex-wife has spent something like $1.5 million litigating against me in a case that's supposedly only worth a maximum of $500,000, and started off as just being basically a divorce. Why and how would anybody spend $1.5 million fighting somebody over $500,000? It doesn't make any sense. And it's for this reason that I believe that this multinational corporation is the one that is funding her, that is behind all of this. Now, I discovered fairly recently that California's DVPA, that's the Domestic Violence Prevention Act, contains a provision in it where acts of impersonation can be considered domestic violence. And you can bring a restraining order hearing against your ex-wife, in this case, if you can prove that she committed impersonation as defined in this one particular penal code. It's called Penal Code 529 in California. Okay, and this provision of the DVPA is set out right there in black and white at Family Code 6320A. Okay, so the fact that you can bring a restraining order hearing against your ex for impersonation is a matter of statutory black letter law. Okay, there's just no question. It's Family Code 6320A, and it specifically references Penal Code 529. It's just right there in black and white. So now in my case, I was able to discover a whole stack of music contracts where my ex had forged my signature. And I also discovered credit card applications where she had forged my signature. And I discovered publishing company founding documents where she had forged my signature. And so she was falsely entering all these contracts that had all these terms that I didn't agree to. Like, she would sign that I was only a 25% writer and she was 75% writer, when we had this agreement that everything was supposed to be 50-50. And then she put herself down as 100% writer on a whole bunch of stuff. And then she had all these secret bank accounts and these separate bank accounts. And so she was using that to just channel the money to herself and then into her solely held real estate properties and all this stuff. So she was just like systematically ripping me off, and I could later prove through emails that I found that the record company guys knew all about it. Okay, so I retained handwriting experts, two different ones, two independent handwriting experts who both did the analysis, and they came to the professional opinion, the expert opinion, that these signatures were forgeries. Okay, so I retained an attorney, and we brought a domestic violence restraining order hearing against my ex-wife based on a lot of things, but the number one thing right at the top of the list was impersonation. As I explained, the DVPA explicitly says, okay, false personation as defined in Penal Code 529, that's domestic violence. And we had handwriting experts and the whole bit. So we get to trial, and this was just last week. October 2nd was the first day of trial on this. And we show up, and I've got my book of exhibits where I've got the bank account stuff and the contracts, the signatures. Those two expert witnesses are waiting in the hallway to be called as expert witnesses. And we're good to go. And so my attorney put me on the stand, and I started testifying. Well, actually, before that, let me back up. So the first thing that happened in the trial was the judge just ruled to exclude the handwriting experts. And what the judge said was that she had been researching the case law, and she had not found a case where purely financial abuse was found to be domestic violence. Now, the moving papers that brought this action set forth the statutory law that I explained. The DVPA explicitly says that impersonation is domestic violence. It's black letter statutory law. You don't need any case law. It's the law. But the judge has said, I find the handwriting experts irrelevant to this case. And she sent them away. Didn't even let us call them as witnesses. I get called onto the witness stand. I've got a book of exhibits that we're trying to admit into evidence. I get through about 14 of 34 exhibits testifying for a couple hours about stuff. And that was the end of the court day. The matter got continued to the following Monday, which was October 7th, 2019. So on October 7th, we show up to court, and we're ready. We've got more documents to authenticate, and we're good to go. I'm still on the witness stand, and the judge, rather than putting me back on the witness stand and continuing on with the trial, excuse me, the judge just, first she repeats, says, I don't find any case law where purely financial abuse is domestic violence. And my attorney first said, any act that can be enjoined, that means a restraining order put on you, any act that can be enjoined under the DVPA. And that's true. But then, I'm sitting there with my laptop, and I shove my laptop over so that my attorney can see it, and I point to the exact statute, and I have him read it. And my attorney read the law right onto the record to this judge. DVPA 6320A says, any act that can be enjoined as false personation under Penal Code 529 is domestic violence. That's exactly what the law says. And he read it to her. And the judge just ignored that completely and just stopped the trial. She said, I'm not going to issue a restraining order at this time, and that's it. Everybody go home. Now, this judge just ended the trial. Okay, that's wrong. Okay, that's not a bad decision. That's a judge just acting outside the law. I was still on the witness stand. I had not finished testifying. Okay, we had no opportunity to call the defendant, okay, respondent actually, okay, my ex-wife, okay, she needed to be called to the witness stand. Well, there was no opportunity to make a closing argument. And then if you look at the ruling that the court actually made, a judge in making any kind of order or ruling is required to set forth the factual findings and the legal reasoning why they came to this particular order or judgment or ruling, whatever it is. The judge did not do any of that. There's no factual findings. There's no law, anything. It just said both parties appeared and testified, and a restraining order is not going to be issued at this time. Okay, first of all, that was absolutely false, because I did not finish my testimony, so I cannot be said to have testified. I testified some, but the part where she said the other party, my ex-wife, where the judge said that she testified, that's just a lie. Okay, we did not even get to call her. We didn't get to make a closing argument. This is just absolutely outside the bounds of the law. So, can we appeal? Yes, we're going to appeal. But I'm also trying right now, and I just filed yesterday, something called a motion for a new or further trial. And so the grounds for asking for a new trial are, there's basically three things. One is an irregularity of court proceedings, which we certainly had. And then a prejudgment of the case is one thing that constitutes an irregularity of court proceedings. But all of this, I mean, just stopping trial in the middle, that's clearly an irregularity, prevented me from getting a fair trial. That certainly should be grounds for a new trial or to further trial. Basically, you just pick the trial up where it left off. The second grounds for a new trial is, well, what is it? Hang on a second. I can look at my notes here. So the second grounds for a new trial is accident or surprise, which ordinary prudence could not have guarded against. That certainly was the case at this trial. I'll put trial in air quotes, right? How could I have prepared for the fact that this judge was just going to stop the trial? I know you're still on the witness stand, but it doesn't matter. I know that you just read me the statutory law, but it doesn't matter. Well, how could we have prepared for that? We could not have. So ordinary prudence could not have prevented that accident or surprise. And then the third grounds for a new trial is error of law, occurring at the trial and accepted to by the party making the application. Okay, so we absolutely have that, right? It's an error of law. I mean, the law absolutely says in 6230A that if you have impersonation as defined in Penal Code 529, that's domestic violence. So we had 12 counts of it, and handwriting experts and the whole 9 yards of bank records, and we had all of this. Okay, there's no question that this woman is impersonating me in order to benefit herself, and she's operating these online royalty accounts and all of this. There's just no question, and there's no question that I can prove it. Okay? So, and there's no question that my attorney accepted to it. He read her the law on the record. On the record. So any one of those, irregularity in the proceedings of the court, surprise that prudence couldn't have guarded against, and error in law. All three of you. Any of those should give me a new trial. We got all three of them, like times 10. So it's troubling. And it's especially troubling because I just found out yesterday that in addition to these other contempt charges that I'm not quite able to talk about just yet, these 3,000 counts of contempt, in addition to that, they are now, they being my ex-wife's army of high-paid lawyers, hell-bent on destroying me, to silence me, say that when I filed this motion for a new trial, that was more new counts of contempt. Why would they say this? Well, they would say this because of the curious and amazing little fact that I've been declared a vexatious litigant. Now, I'll have a lot more to say about that in a future talk and in my book, if I ever get the chance to write it, because, oh boy, do I have one hell of a book with a lot of chapters. I mean, this, what I've been going through today is only just what happened in 2 weeks, just recently. This has been going on for well over 4 years, and I have instance after instance. I have just corruption after corruption, and I have absolutely all of the documents that prove and back up everything that I'm talking about, and I have the legal training and to know what I'm talking about. So hopefully I'll get a chance to bring all that. But this vexatious litigant thing. So what that is there's a law in California where if you repeatedly bring frivolous motions or frivolous lawsuits, they can declare you a vexatious litigant, and then after that, you have to get the court's permission to file anything. That's basically what it means. Now, in my case, they got this order against me about a year and a half ago in family court, and that too is just completely bogus. I've never, not a single one of my motions that I've ever brought has ever been found to be frivolous or harassing. Not a single one. And then moreover, as I explained earlier, that first federal case that I brought for copyright infringement, I won that. And then I even won on appeal, okay? As a pro se, representing myself against these giant, hugely paid corporate attorneys. I mean, if you know anything, that it is so unbelievably unusual for a person representing themselves, a little guy, to win anything, let alone an appeal case in the Ninth Circuit Court of Appeals against corporate attorneys. And I did. And yet, in the vexatious litigant order, the judge in that one just got it completely wrong. He just falsely stated that I had lost that case. It was just false. It was just false. And then the only time that any judge ever said that anything that I did was brought to harass or delay was in the domestic violence restraining order hearing against me. Okay, so I'll have plenty more to say about that whole thing that started, it went from late 2016 through like September of 2017, where my ex-wife sued me for a domestic violence restraining order. Why? Because I was suing her, and they ultimately found that my litigation was domestic violence. And I'm not making that up. That's a case that I eventually brought to the Supreme Court, This is the insanity that's now going on. Is my lawsuit, most of which is still pending, and it's actually set for a jury trial, but it's been found to constitute domestic violence, whether the lawsuit has merit or not. And that's exactly what the judge said. Anyway, the only time that a judge ever found that something that I did was to harass or delay was in that DV hearing where I was a defendant in that. So that's not me bringing a harassing anything. That's my ex-wife bringing something against me, and all I did was file defense papers in my own defense. And in particular, at one point during that proceeding, I brought a motion trying to remove the judge for bias, which you can do. There's a law that says you can try to do that. Of course, they didn't grant that, no surprise. But that's what that judge found that I was doing, to harass or delay. And so they found that constituted domestic violence. Just the mere fact that I tried to get the judge removed, that was domestic violence. But then the later judge in the vexatious litigant thing, he pointed to that and said, see, this other judge found that he brought this to harass or delay. Well, that wasn't anything that I brought. I was a defendant in that. The vexatious litigant statutes are supposed to prevent people from filing frivolous lawsuits. That was nothing that I filed. That was her case against me. Okay? So that's the vexatious litigant thing that I'm up against now. One, they just out and out lied and said that I lost that copyright case when I actually won it and won it again on appeal. And then that thing where I supposedly brought something to harass or delay, and because I tried to remove the judge, who was clearly biased. And I'll talk all about the bias that I actually proved. That'll have to be another talk. But right now what's important is that the vexatious litigant order says that I'm not allowed to file any new lawsuit, basically, or any new motion without the permission of the judge. So they want to argue that by filing this motion for a new trial, which I just filed yesterday, that's new act of contempt. It's like 5 or 7 new acts of contempt, or whatever they want to say. So I should get additional jail time and additional fines. But the thing is, that vexatious litigant order, it says right in it that it does not apply and it shall not prevent me from presenting my arguments at trial. That's exactly what the vexatious litigant order against me says. Nothing in this order shall prevent me from presenting his arguments at trial. Well, that's exactly what I was not allowed to do at this recent hearing that I just talked about. Okay? The judge stopped the trial, my trial against my ex-wife for impersonation. Just stopped the trial for no explanation, and we weren't allowed to bring a closing argument. Okay? So I don't see how they can argue that the vexatious litigant order prevents me from bringing my arguments when that's exactly what the order says that I am allowed to do. I'm allowed to present my arguments at trial. Anyway, I know this is all, it's a lot. There's just an unbelievable amount of details, and I mean, I guess I apologize for that, but I just wanted to put it out there. You know, I'm having to do a lot of soul searching, and a lot of you know, this has just forced me into a position where I have to start thinking about what my life is about and what is the meaning of my life. And I pretty much come to the conclusion that if my life was going to have meant anything, it is that it was a search for the truth and a desire to, in some way, put the truth out there, to be the messenger. And they say don't shoot the messenger. Well, they're getting ready to, and I'm fighting this. I'm gonna fight this with absolutely everything that I have, and I am gonna try to write my book, and because oh boy, do I have a hell of a story to tell. A lot of people have asked me, and this is just in closing before I let you go. A lot of people have asked me lately, my friends, right? What can I do? What can we do to support you? And if anybody out there knows of any journalist or documentary filmmaker or writer, author, nonfiction, somebody who does hard-hitting, controversial stuff. There's at least a few people like that out there. I have a hell of a story, and this is a story of how I'm in the process of becoming a political prisoner, and they are absolutely intent on silencing me and putting me away, and I'm going to fight it. I don't know how it's going to turn out. I do not know. But I do know that there are a lot of judges who just make up the law. They just do whatever they want without any accountability. And they've done it to me over and over and over again. And there are very powerful attorneys who all they want is the money, so that's, I guess, about all I have for right now. And I thank you for listening.